For more, we can speak with Professor Joshua Kastenberg from the University of New Mexico School of Law. Good to speak to you about this. June 2027, that's nearly a year away. Why is it likely to take so long?
Well, there are going to be significant pretrial motion practice, particularly in regard to whether or not a U.S. court even has jurisdiction over former President Nicolas Maduro in the first place. As you heard a moment ago, there's a doctrine of sovereign immunity, and generally both international law and international law recognized by constitutional law scholars in the Supreme Court prohibits prosecuting foreign leaders who are simply doing their job, no matter how distasteful their job is, when they're in a leadership position um, in a U.S. court. And what makes this more complicated, I think, is that the defense are likely to raise the recent Supreme Court decision of Trump versus United States, which gives the president virtual immunity for any, presidential act, and they'll try to do an inverse argument on that in regard to Mr. Maduro. It'll take a while to get rulings on that.
So you think this could actually end before it's even begun?
Well, I think it's a possibility that it'll end before it's begun or begin before it ends, to put it a different way, because regardless of how the trial judge rules on jurisdiction, that ruling will be appealed by one side or the other to the Intermediate Court of Appeals and all the way up to the Supreme Court. And I don't think that the United States Supreme Court can ignore the jurisdictional issue before there's a trial.
And help us understand how so much of this case will actually hinge on classified intelligence and what will be made
Well,
available.
Yeah, well, that's the second feature of a discussion, because the Sixth Amendment to our Constitution guarantees a right to the public trial. And that's not just Maduro's right, that's the right of the American public to see the trial. And the framers of our Constitution were very unhappy with British trials back at the time of the War of Independence, had a belief that the government could be held in check if the general public was looking in at what they did in a criminal trial. So anytime you classify evidence or you seal the trial off, that leads to significant jurisdictional and evidentiary motions that a district court has to handle too. And so if you're going to have a completely open trial, it's going to limit what the prosecution decides to put on as evidence.
Yeah, I suppose given the nature of how he was brought into America and what he's been charged of, that's going to lead to some interesting discussions. Just a quick question then: has a trial like this ever occurred before in the United States?
Well, some people will say there's the trial of Manuel Noriega, the former president of Panama. But this is different than that trial. The trial of Noriega didn't involve such heady questions of classified information, and also it wasn't a military operation short of war in the same way that this operation was. Obviously, the Army captured Noriega, but there were already boots on the ground, and that has a different sort of feel to it than this one.
Okay, we'll leave it
So
at
the answer is no.
that. Okay, Professor, thanks very much for that. Professor Joshua Kastenberg from the University of New Mexico School of Law.